The last time I spoke for 45 minutes, one of the attendees came over afterwards and said, you know, if I only had 45 minutes left on Earth, I'd want to spend it with you. Wow. I said, that was really pretty flattering, but wouldn't you want to spend it with your family or your friends? He said, no, I want to spend it with you. You're the only one who can make 45 minutes seem like an eternity. So be thankful that you only heard 45 minutes worth, and maybe that did sound like an eternity. In any event, I appreciate being asked to speak here at the Goldwater Institute, one of the nation's really foremost pro-liberty public policy organizations, staffed by people with immense capability, doing an outstanding job in reining in the powers of government and making sure that our rights are protected. And I would be happy now to take a stab at answering any questions that you might have. So Nick will do the honors.
Thank you. My name is Terry Traylor. I was curious, when you strip away health care from the health care bill, how would you title or characterize the contents of the bill that remain?
Well, this is more a policy question than it is a constitutional law question. In the constitutional law area, we're concerned about whether or not the health care bill is authorized under the Constitution. Our health care specialists address the question of whether this is a good idea. Now, I have my own views on the subject, so even though I'm not in the healthcare policy area, I do have some impression as to what ought to be done, and it is this. Why is it that we have a problem with pre-existing coverage of pre-existing conditions? I mean, after all, don't we have the same problem in the term insurance market? What do people do when they want to take out term insurance and they find out that there's a possibility that the insurance policy will be canceled whenever it is that they get sick? Well, they take out guaranteed renewable coverage. Or in some cases, they take out a separate policy that says that if, in fact, your term insurance is canceled and you have to pay a very much higher premium in order to replace the term insurance because you're sick, this policy, this supplementary policy, will cover your excessive premiums. So why doesn't that occur in the healthcare market? It doesn't occur because there's almost no negotiation between the consumer of services, that is, us, and the provider of services, and that is the hospitals and doctors. Why is there no negotiation? Because there's two stages of removal. On the one hand, there is the insurance companies, and on the other hand, there is the corporation that pays the premiums for the insurance company. So almost all of us who have health insurance, if we're working, we have health insurance under the auspices of our employer. How did that happen? It happened because of the fluke, or not a fluke, but actually an intentional provision of their tax code, which basically said when corporations buy health insurance for their employees, they can deduct the cost of that health insurance, and the employees do not have to report that as taxable income. If the employee turns around and wants to buy health insurance on his own rather than through his employer, the employee cannot deduct the cost of the health insurance. So everybody who can will provide health insurance for himself through his employer. And that means that no one monitors either the insurance premiums that are paid because they don't pay them. The corporation pays them. They don't monitor the health insurance provided because they don't pay for that. The insurance company pays for it. And this 2 degrees of separation is the essential problem. It is no secret why the cost of LASIK surgery goes down, down, down in this country, and the cost of MRIs goes up, up, up. One is covered by insurance, and one is not. So if we want to cure this problem, one major thing that we can do is to amend the tax code. Specifically, allow employees a deduction for any monies that they pay to purchase health insurance, and then at least the employees will monitor the cost of their insurance policy, and in turn the cost of the insurance policy will depend upon the behavior and the health condition of the employee himself. This is what we do in every other market. Consumers monitor the quality and the quantity of the services they get and compare that to the price that they have to pay. We do not do it in the healthcare market because either a corporation pays for insurance, which pays the hospital, or we get the insurance through Medicare and Medicaid, where we don't even have a corporate entity, we rather have the government, and the cost is dispersed among all of us, all of our taxpayers. So this break in the link between user and supplier is the root of our healthcare problem. We need more health savings accounts, and we need an amendment to the U.S. tax code to cure this problem.
Hi, my name is Blaine Bouchard. One of the things that you mentioned, which kind of got into some of the points that I've been considering lately, and there are many I could go on for a while, but I'll find it to one. The case that you cited, the case, I forget the name of it, the 1940s, I think it was Filburn. That combined with this mandate, it seems to me, and one of the things I've been concerned about is that a lot of people who are looking at this case, in the general public, don't quite see the scope of what's going on. That combined with this, we essentially are standing at the cusp of an all-inclusive, all-encompassing federal government. That if the federal government is allowed to legislate that and mandate that we are required to purchase something and be penalized for simply not engaging in commerce, then it seems to me that there is no limit to what they could or could not do. That the federal government would have the ability to override and negate any state, county, city, or other local law. And it would essentially be an end to state sovereignty. Do you agree with this?
Well, even worse, it would be an end to limited government. State sovereignty is a noble goal, and I'm all for state sovereignty. This that you described is the essence of the problem, and it would simply eliminate any constraints whatsoever on the power of government. Indeed, the government can force us to buy a product from a private company, health insurance. Why can't it force us to eat celery, as I mentioned? Why can't it force us to purchase exercise equipment, or tell us what to eat, or which television shows we can watch? There would be no limits on federal power. And now the Supreme Court has allowed the Commerce Clause to expand beyond any original conception of what it was intended to mean. We are hopeful that the current Supreme Court, which is a bit more conservative, that the current Supreme Court will have sense enough to realize that there is a limit to what the Commerce Clause can cover, and will hold that the Commerce Clause does not extend, even if it extends to regulating the production of wheat, even though there's no commerce involved and there's no interstate transaction involved. Even if it extends to that, it does not extend to forcing us to provide a subsidy to wheat growers by requiring that we purchase so much bread at the grocery store. So this is the essence of the argument that we're going to be presenting to the higher courts. Now, as you know, we've won in Virginia at a trial court level. The oral argument is today in Florida. Today's the 6th. So the oral argument in Florida, that's Florida plus 20 other states plus the National Federation of Independent Businesses, all one lawsuit. That oral argument's today. We, in accordance with a preliminary opinion that the judge issued, we're very hopeful that we're going to win in that case as well. Now, these cases go up to the appellate court, including the cases that we lost, one in Virginia and one in Michigan. They go up to the appellate court. We need to win one of those cases in the appellate court to give us a real good shot at Supreme Court review. And there, the court is a pretty decent court, and we are hopeful that at last the court will put some limits on the Commerce Clause.
I have a devil's advocate question. If the conservative position is that the powers of the federal government are limited to the enumerated powers, then it would seem that the federal government should not be regulating a woman's right to an abortion. By the same principles, why would we allow our state constitutions and our state governments to take that power away from an individual woman and put that power in a state?
Well, this is a tough question, of course, and a very emotional question. So let me tell you what the constitutional position of libertarians, or at least my position, and I think other libertarians as well, perhaps not all. And that is that the abortion question should really be divided into two parts. The first part is, when does life begin? And that, of course, is the threshold question which dictates the answer to whose rights are involved. If indeed life begins at the point of inception, then abortion's murder, and you cannot murder under any state law. If life begins when the fetus emerges from the womb, then we're talking about the rights of the woman to control her body. That threshold question, when does life begin, dictates the answer to the abortion question. Now, that's a question that's beyond my competence, and I think it's beyond the competence of the judges or the justices on the courts. This is a question for theologians, for philosophers, for scientists. There is a second question, however, and that is, who gets to decide the first question? And that is a legal question. That's a constitutional question. And here's what Blackmun wrote in Roe v. Wade, in the 1973 Roe v. Wade case. I'm not quoting exactly, I don't have it in front of me, but it's pretty close. He said, when in this stage of development of our knowledge in theology, in philosophy, in science, in morality, it is impossible to say when it is that life begins. Far be it that these 9 justices on this court should be able to venture into this area and make that determination. And then, having made that very sensible point, he then proceeded to do exactly what he said that the court should not do. And he decided that the federal government, specifically 9 justices on the U.S. Supreme Court, could make the decision as to when life begins, and we end up with the trimester approach in Roe, or as it's now been modified by the 1992 Planned Parenthood v. Casey decision, the post-viability, pre-viability distinction in that case. So this is quite extraordinary, and the conservatives were hypocritical on this, and the liberals were hypocritical. And to illustrate that hypocrisy, think about the case of Terry Schiavo in Florida, a young lady who was in a vegetative state, and the question was when it would be permissible to pull the plug. And there was a battle between her parents and her husband. And what was the conservative response? The conservative response was for Congress to instruct the federal courts to step in and tell the state of Florida what the rules ought to be in terms of preserving the life of Terry Schiavo. That was the conservative response in the Schiavo case. Let the federal government tell the states what the rules should be. How does that compare with the conservative response in the abortion case, which is Roe v. Wade is an abysmal decision. Why? Because the states should be 50 experimental laboratories. It should be up to each state. They should make their own decisions. Just hypocrisy. What about the liberal position? Every bit as hypocritical. Just the flip side. When it comes to Terry Schiavo, the liberal position was, we want every state to make up its own mind. When it comes to abortion, the liberal position is we want the federal government to step in. We cannot trust the states. The federal government has to dictate the law. The libertarian position, I think, is much more straightforward, much more intellectually honest. And that is, this does not come within the mandate of the U.S. courts. This is a decision that is not based on legal analysis. It is a decision that is beyond the competence of the court. And when we have issues like that, we need to leave those issues up to the political branches. And when we do leave issues up to the political branches, it ought to be the political branches at the lowest possible level, which in this case is the states. Now, I say that as somebody who's pro-choice. And if I were a state legislator, I might vote for a regime that's very much like the regime that we now have under Planned Parenthood v. Casey and Roe v. Wade. But it is not the function of the U.S. federal courts, particularly the Supreme Court, to make that determination. I do think it ought to be left up to the voters of each state as expressed through their elected representatives.
Back to your healthcare litigation, it sounds like a slow process. And so what are the chances 4 years from now when it gets to the Supreme Court and all the stuff's in place, billions and billions of dollars have been spent, all people hired, that they actually then roll something back?
Well, it won't be 4 years. I think it'll be a matter of months before we have an appellate decision. And if the appellate decision goes the right way, then there will be grounds for the Supreme Court to get involved. And I would expect, they won't get to it this year, but I would expect a year down the road they'll get to it. The mandate doesn't go into effect until 2014. So before 2014, I think we will have a decision from the U.S. Supreme Court whether the mandate can be justified either as a regulation of interstate commerce or as an application of the taxing power to provide for the general welfare. Those are the two claims that the government is making, the federal government, and I think the court will give us an answer to that well before 2014.
We have time for one more question. Show me the way.
Okay, please go.
Yeah, maybe, I don't believe it's my imagination, and I believe I see that the state governments themselves have been getting more and more involved with the federal political process, as you see more of the states, as has been indicated, initiating lawsuits against the federal government or for the federal government to decide. Is this a practice that is relatively new, where the governors themselves or their state attorney generals are going and initiating lawsuits to get the laws turned for their direction? Is this something we could expect to see increases of in the future, or will it go back to the old system where the governors themselves do not get involved in the process?
Well, of course, a lot depends on who the governors are. Now we have an influx of governors and state legislators that are much more sympathetic to limited federal power, and that's why we're seeing this. That's one reason. The second reason we're seeing it, thank goodness, for the Tea Party. You know, the Tea Party, whatever else you may think about the Tea Party has done two very, very important things. If it's done nothing else, it's done two very important things. Refocus our attention on the U.S. Constitution and what it was intended to mean. And secondly, limited government, reduce spending, lower taxes, get the government out of our wallets and get the government out of our lives. That, I think, is a very healthy development. Let me mention one other thing that's on the horizon that I think you ought to pay some attention to if you haven't seen it already, and that is the repeal amendment. This is an amendment that's been sponsored by, actually, I think drafted by a colleague of Goldwater's and my colleague, Randy Barnett, who's a law professor at the Georgetown University in Washington, D.C. This is called the repeal amendment. And the repeal amendment says that if 2/3 of the states want to repeal a federal law or administrative regulation, they can do so. 2/3 of the states. Now, the nice thing, this is not nullification. Nullification differs in two respects. First, nullification gives every state the power to nullify a law that they think is unconstitutional. This is the requirement that this would be a constitutional amendment. It would be that 2/3 of the states have to declare that a law is to be repealed. So that's one difference. 2/3 of the states are required. Second difference is very important. This does not require a determination that the law is unconstitutional. It requires a determination that the law is bad and should be repealed. And so you could have 2/3 of the states voting to repeal Obamacare, even if it were determined that Obamacare is justified under the U.S. Constitution. And even, I think equally important, these states could also vote to repeal administrative regulations. Now, this would be a means of offsetting the deleterious effects of the 17th Amendment, which shifted the election of senators to, as you know. So, I think this is something that warrants our closer attention and our support, and it's going to get more and more discussion as the months unfold. So I think we're out of time, and I want to thank you very much, and thanks to the Goldwater Institute.
Well, I just wanted to thank Bob Levy for coming out again and enlightening us, and I think I've said this before, but I'm ready to spend another eternity, so please come back. And thank you for your support from the Goldwater Institute.
Please keep warm up.